Hey folks, Denise Howell here, and next up on This Week in Law, we're going to talk about all the IP ramifications around iTunes Match. Who remembers Napster? We all do. Are we going to be legitimized? We're going to talk about that. We're going to talk about who owns your tweets, privacy on Facebook, IP and the workplace, and more next on This Week in Law.
Netcasts you love.
From people you trust.
This is TWiL.
Bandwidth for This Week in Law is provided by Cachefly at CACHEFLY.com.
This is TWiL, This Week in Law with Denise Howell, episode 115, recorded June 10, 2011. Double-fisted on Facebook. This episode of This Week in Law is brought to you by Netflix. Watch thousands of TV episodes and movies streamed to your PC, Mac, or TV instantly. Plus, get DVDs by mail in about one business day. For your free 30-day trial, go to netflix.com/twit. And by Squarespace. Squarespace.com is the fast and easy way to create a high-quality website or blog. For a free 14-day trial, go to squarespace.com/twil and be sure to check out their annual plans for savings of up to 20% off. Hello and welcome to the Real Housewives of Orange County. No, wait, that's not quite right. The Real Lawyers of Silicon Valley. Not quite that either, but you have tuned in for This Week in Law. And I am filling the role of the Orange County housewife / technology lawyer, so take that, stereotyping network television executives. I'm joined by another Orange County fellow resident this week, a good friend, Edson McClellan, who works with my husband at Rutan and Tucker. Hello, Edson. Great to have you on the show.
Hi, Denise. Thanks for having me today.
My pleasure.
This is my first time ever doing a show like this. I'm excited.
Good. We're excited to have you. And we're really excited to have you. Edson is an employment lawyer, and he is the person I frequently, in my own technology law practice, have these employment-related, workplace-related issues crop up that sort of come out of left field because of the vast influence that social media is having on the workplace these days. And Edson is always there, the person I pull in to deal with these issues. So I thought it would be only logical and great to bring him on the show and have him talk about that kind of stuff with us here today. So thanks so much for joining us, Edson.
I'm psyched to be here.
Also joining us, a newcomer to TWiL, is Michael Barkley. Michael's up in Silicon Valley and a former partner at the preeminent Silicon Valley law firm, Wilson Sonsini, and now volunteers and has written a whole slew of amicus briefs, co-authored others in some very important IP cases. Michael, great to have you on the show. Let's see. Do we have Michael muted?
I can.
There we go.
Can you hear me?
Yeah, we can hear you.
Okay. Let me know if you want me to turn the sound up.
No, you're doing great, and it's wonderful to have you. I love your blog. Michael writes the IP Duck blog, which mixes two of my favorite things in the world, intellectual property and humor. And so you can go to Michael's blog and read in-depth analyses of the latest nuances from the Ninth Circuit on DMCA safe harbors, and you can also have links to Darth Vader visits Disneyland. So it's really one-stop shopping for everything you'd ever need to know. Thank you so much, Michael, for providing that and for coming on the show.
Thank you. And for some reason, people like the Darth Vader video a lot better than the DMCA analysis, but we'll leave that for some other time.
Well, you're the perfect guest for TWiL then, because I would say that here we like them in equal measure. So you're a very good fit for us. Also joining us once again, our very irregular Evan Brown. How are you, Evan?
Well, hello there. I'm doing great, and thanks for having me. This is another one of those episodes where I'm, so happy to be invited to your West Coast party. So great to be joining in here from Chicago. It's good to be talking to you.
great to have you once again. And I am just dying to get into all our stories for this week. I don't really know where to start because there's so much exciting stuff to talk about. I think we'll start with something that legitimately qualifies as breaking or just having broken news, and let Michael bring us up to speed on the very large decision out of the United States Supreme Court yesterday in Microsoft versus I4I. This is a patent case that has been winding its way through the courts, involves a $290 million verdict against Microsoft. Michael, can you tell us what that's all about and what it means that Microsoft lost before the Supreme Court? I believe it was yesterday.
Yes, it was just yesterday. This case started out when I4I sued Microsoft in the district court in the Eastern District of Texas over a patent I4I had on a feature called XML editing, which at one point in time was in Microsoft Word, but Microsoft did not use it very much, but the case went to trial anyway. The I4I damages expert convinced the jury to award $290 million on this feature, which Microsoft then took out of Word, and I doubt if anyone listening to this even noticed that happened. Microsoft appealed to the Federal Court of Appeals for the Federal Circuit, which hears all patent appeals in the country, and lost. The main issue Microsoft appealed on was damages, and without getting into the civil procedure aspects of this thing, Microsoft did not deal with that issue very well at the district court level, and it didn't work well at the appeals level. What Microsoft did do from a civil procedure level is preserve an issue on proving invalidity of a patent. In a patent case, the patent owner or the plaintiff has to prove the patent is that they own the patent and that the patent is infringed by the defendant and that there's damages, but the defendant has to prove that the patent's invalid if the defendant wants to make that argument. And Microsoft apparently had some good what's called prior art references, some earlier uses of the patented invention that had not been considered by the Patent Office when the Patent Office decided to issue the patent in the first place. So Microsoft had preserved the question of whether a defendant in a patent case has to prove a patent invalid by what's called clear and convincing evidence, meaning it's highly probable, or merely by a preponderance of the evidence, which is what's called, which is more likely than not. You might think about preponderance of the evidence as something like 51-49, and highly probable or clear and convincing is 75-25 or 80-20 or something like that. For 30 years, the Federal Circuit Court had held that the standard was clear and convincing evidence whether or not the prior art in question had been considered by the Patent Office. Now, if the Patent Office had considered the prior art, you would say you're just trying to challenge what a government agency already did, so there might be some reason for a clear and convincing standard there. But where the prior art hadn't been considered, there's really nothing to defer to. So Microsoft asked the Supreme Court to hear the case, which the Supreme Court doesn't have to do in every case, but the Supreme Court decided to do that in this case. And I co-authored the Electronic Frontier Foundation's brief, friend of the court or amicus brief, asking the Supreme Court to take the case. And they did take the case last November, and the case was briefed and argued in April. And yesterday, the Supreme Court affirmed the Federal Circuit rule of clear and convincing evidence. Now, usually when the Supreme Court takes a case it doesn't have to, there's a good indication that it took the case to reverse, because there's no reason to affirm a case where the Supreme Court likes the rule that the lower court adopted. I think I read that there's something like a 70% reversal case in the Supreme Court. So when the Supreme Court took the case, we kind of figured the Supreme Court perhaps did not like the Federal Circuit rule, and indeed in at least two other important patent areas in the last 5 or 6 years, the Supreme Court has reversed the Federal Circuit rule. So we were a bit optimistic the oral argument in April did not go very well for Microsoft, somewhat surprisingly, and the and given that oral argument, not surprisingly, yesterday the Supreme Court affirmed the Federal Circuit. So this is disappointing not only for Microsoft but also for many other tech companies and open source companies who have to deal with patents that are somewhat marginal. The big pharma and biotech companies filed briefs supporting I4I, and they obviously are quite pleased with the result. So that's a summary of what happened.
Wow, it's like insult to injury for Microsoft, who's got to see its market share in Word diminishing as more and more word processing services move to the cloud, and now it has to face this enormous verdict in this patent suit, which sounds like, we've talked a bit on the show in prior recent episodes about the concept of taco suits. I think it was, who was it that coined that, Evan?
It was Nilay Patel.
That's right. It was Nilay Patel who said, the Taco Bell class action, et cetera. And we've sort of used this now as our shorthand for lawsuits of questionable merit. And it sounds like this one might fall into that category, although I certainly haven't delved into the briefs in any detail. But this one resulted in a $290 million judgment, which is kind of rare for that sort of suit. Evan, any thoughts on this one?
Well, I mean, more of a question, I guess. I've never seen a straightforward answer to this question, and that question that I'm pondering is this: doesn't this decision from the Supreme Court help out the cause of what we call nicely non-practicing entities, or what we call not so nicely patent trolls? Isn't this going to make litigation by patent trolls, those companies who just hold these patents in their portfolios but don't develop or manufacture distribute any technology that has that patentable subject matter in it, but they just go around suing people? Doesn't this help them, and isn't this going to encourage more patent troll litigation?
The non-practicing entities filed briefs supporting I4I. So along with I should have added them to my list of people who were happy with yesterday's decision. Along with the pharma companies, the non-practicing entities are very happy with this.
Well, that's interesting and somewhat disappointing, but thank you for the update. Interesting and not necessarily disappointing is Apple's announcement about its iCloud services, and the part of it that fascinates me the most, iTunes Match. And I really want to get into talking about that with you all here, and the intellectual property shades to it. For me, my jaw has sort of been down on the ground most of this week as I have pondered the ramifications of iTunes Match, and the fact that it seems to me the end of a 14-year progression that started out with mp3.com and Michael Robertson, and the notion that you would, I believe that was 1997, that you would pop a CD into your computer and they would identify it and give you access to those tracks from the cloud. And then Napster coming along in 1999, and people developing their enormous illegal music libraries courtesy of Napster and its progeny. And then both of those companies being driven out of business in high verdict, high profile litigation, high damage dollar amounts. And now finally, Steve Jobs has come in and brokered a deal, some would say a very, very slick deal as far as what was paid for it. $150 million sounds like a lot of money, but when you think about it in the context of the copyright damages that could be awarded for all those infringements out there, or you think about it in terms of the revenue that could have been made had the music industry, gotten there earlier and done this the way users wanted 14 years ago, $150 million starts to sound like not so much money. plus whatever the percentage of the $25 a year annual fee for access to these things. So to back up for a second, for anyone who's not too familiar with iTunes Match, what this is going to do is allow Apple to survey your music library, however it may have come to exist locally on your hard drive. And for anything that it can find a match to, it has 18 million songs in its library to draw from. It's going to give you access to those tracks in a nice high-quality AAC format, which may be better than the quality than on your hard drive. It may be worse, but I think in a lot of instances it will be better. And you can then access it on all of your authorized Apple devices for the low price of $25 a year. So for those who have developed these large illegal libraries, it sounds like sort of Amnesty non-international, Amnesty domestic, since it's only available in the US at first. So let's talk about this thing and try and unpack it. Michael, what are your thoughts having watched all this unfold?
So you're right. It is very interesting how MP3.com was sued for a similar service and essentially put out of business 10 years ago or so. Apple was able to use its licensing clout with the major record labels to get this done. The real interesting thing is that if you look at how the content industry has been either expressly or impliedly talking about revenue streams for a long time, they have always wanted to have a rent model than a buy model. The content industries would prefer that people actually just not be allowed to own physical copies of the media with the content, but rent it from them. So if you have streaming Netflix, you have to pay a fee every time you want to watch a movie. Now you're paying $25 a month for music you already bought.
A year,
my understanding
actually.
$25 per year, I'm sorry.
Yeah.
So, and my understanding, the record labels are getting 60% of that or so of that revenue. So this is something they've always wanted to do, and now they're getting able to do it. So I think they could have made similar deals like this with MP3 and with Napster a long time ago. Now they're finally getting around to do it, and I think that's a good thing. We'll see how it works. We'll see if it produces a lot of revenue, both for Apple and for the labels, and I think this is preferable to the years of litigation we've had in these areas.
Evan, Bob Lefsetz, very respected and prolific commentator on the music industry, thinks the record companies got fleeced. Do you agree?
Bob Lefsetz takes a very interesting perspective on this because, I mean, what he's essentially saying is that the iTunes Match, paired with the iCloud service here, has killed the model of subscription-based access to music. Like the most recent incarnation of Napster and Rhapsody and stuff like that. So he's saying that the record companies, the studios, got fleeced in that way because they would have been able to advance the distribution mode a little bit more and make more money had they given away a certain amount for free and then elevated it like the mobile industry does and like the cable companies do, where you get people in on the ground floor and then you slowly add on features to charge them more, and that's where you really make money. So the real interesting thing about Lefsetz's conclusion on this is that what we are doing here, or what Apple is doing here with the iTunes Match and the iCloud, is essentially making it a 20th century model where you actually have to pay for the music to hear it first. And it's a very intriguing argument that he makes here. It's one that should be able to be borne out in an economic kind of analysis here. So, we could leave it to the more empirical analysis to see whether or not what he's saying actually is true in reality. What I find most interesting is that even though this is something that is more innovative technologically than a subscription-based model, from a revenue standpoint and from an overall market strategy business standpoint, it's interesting to see it as really a throwback to the old system, in the same way that you have to go in and buy the vinyl album before you can actually listen to it. You have to somehow acquire, this is of course setting aside for a moment apparently the vast amount of pirated music that's going to be put up into the iCloud. You have to buy the music first in order, or somehow acquire it first before you can hear it. So I think it has to be an economic analysis, and evidently it's too late now if these licensing deals have already been inked with Apple and the labels.
Right. So let's not leave the piracy issues aside and get into them. The question I keep getting over and over, and we've just gotten from Web 9573 in IRC, he or she says, it's amazing to me that nobody sees this as a big trap to see exactly what music people have in their collections. Music matching is a way that the music industry will see exactly what was stolen. Once you stop paying, what will happen to your collection? Does the music go away? I see it as a trap and a window into your collection. So Apple has responded to this whole we're going to share information point, and the response I've seen on that is that they're not going to know, first of all, anything about where your collection has come from, unless there is some sort of digital fingerprinting on it that marks your file as having been pirated. There's no way that they would have known the provenance of what is there on your hard drive. Now, what I haven't seen a response to is the fact that there's going to have to be some log file somewhere that keeps track of what was matched, and so there is going to be some paper trail. But Apple, I believe, has said they're not sharing that paper trail automatically. Now, that's not to say that it couldn't be subpoenaed at some point down the road. But so here's the interesting conundrum. I called it amnesty domestic, but it doesn't necessarily have to be, it doesn't make economic sense for the record industry to decide, okay, we're going to make money finally off all of these illegal downloads. We're going to get our 150 million. We're going to get our subscription fees, but we're going to preserve our rights. If there is someone with, a vast pirated music collection, to go after that person, I think it will be incredibly interesting and entertaining in the event one of these RIAA suits falls down on someone who is an iTunes Match subscriber, and they're going to throw that into the mix, possibly as some kind of affirmative defense, or at least as some sort of sympathetic plea in their lawsuit, saying, hey, I've been paying for this stuff de facto on iTunes Match. And I think the response to that would be, that's not what you're paying for, and we still have rights to come against you. So, you could loosely call it an amnesty, but what it really is, I think, is a way of allowing the music industry to selectively enforce who they're going to go after. It doesn't really give them any sort of bar against pursuing people, except for an economic one. Would you be stunned, Michael, if someone who was an iTunes Match subscriber also came under fire in the form of a lawsuit from the RIAA?
Well, several things. One is the slew of user lawsuits that the RIAA was filing about 3 or 4 years ago seems to have died down. Correct me if I'm wrong about that.
It has died down, but I don't know that it has gone away entirely.
Well, the legal right is still there.
Saying that it will.
Yeah. The legal right to sue is still there, certainly.
Right.
If the RIAA were to file these suits against iTunes Match customers, it would kill the service, because anyone with any sort of any music file on their hard drive of possibly unknown origin will just not sign up at that point if that's what happens.
Right.
And for example, I'm personally pretty careful about only having music in my iTunes library that I either uploaded through a CD I own or that I bought from iTunes. But it's hard to be 100% sure about that if you have a lot of music for anybody. So it would just kill the service. And if the RIAA thought that those lawsuits were effective, in reducing piracy, it probably would still be filing them, I would think. So
Yeah.
I think to use this as a backdoor is not economically a good idea. Having said that, there's always a problem when you deal with when you opt to deal with things like the cloud or Facebook or other things. You are getting information out there, and your music files do have metadata in them, computer data that's not part of the actual music that potentially do have identifiers of where the music came from. So there is a potential by signing up for this that Apple at least could collect information that maybe the user does not want anyone else to have.
Right. The irony of this thing to me is that, it's been a long, long time since any illegal music found its way onto one of my hard drives. I will cop to back in the Napster days. I tried it. It was fun. It was amazing. It was an incredible service. It was a great way to get music. It was a wonderful music discovery tool. And, I remember that sort of sense memory from a long, long time ago. But the irony of this announcement is you've got storage for up to 25,000 songs. In my various iTunes libraries now, I have maybe 10,000 tracks total. So I've got 15,000 tracks that I have room for on iTunes Match. And the temptation is to go out and start downloading willy-nilly again on the assumption that one is not going to be sued if one is participating in this program. Now, I'm not saying that's a good idea, but I do think it's a strange incentive that goes along with this kind of announcement. I'm sorry, we've got Edson on here to talk about a lot of social media and employment, workplace-related issues, and we've been talking about IP up until now. But I do want to bring you into the discussion, Edson, if you have any thoughts about iTunes Match and what's going on here. Just out of curiosity, what is your music situation, and do you have any comments about what we've been talking about?
I'm a novice with iTunes, and I use my iPod, but as far as the legal issues you're discussing and those developments, I really am not in the loop.
All right, so we're going to get to you on some things more in your wheelhouse in a second.
Yeah.
Meanwhile, Evan, any final thoughts on anything I just commented on, or on the fact that Bob Lefsetz also thinks the artists are getting left out in the cold here?
Yeah, that's an important thing if the artists are getting left out. And that would, ostensibly be tied to how much the studios are selling out on all of this. So, the only point that I would want to add to this is to kind of curb the fears that people have that this is going to be a way to track piracy and to track down people like this. The ecosystem in which these files are being uploaded and transferred and used is much different than the open web or the open internet, like it was in the, even with all the P2P models, going back to Napster, Grokster, Nutella, even with the BitTorrent model, because there, it's out in the open and it's up for the investigators, working for the record companies to track down IP addresses associated with this sharing. So it seems to me that there's an important barrier to the investigative process here, and that is the fact that the share or the transfer of these from the local device up into the iCloud service and back down to other devices that are registered with that Apple account are essentially in their own little silo. So it's going to be very difficult for any investigators working on behalf of the movie studios to figure out who to send for whose information to send a subpoena, trying to find out who that is. And that obscurity seems to me to be just as important of an obstacle and therefore a safety barrier to this kind of investigation, to this uncovering of piracy, as Apple's own promises that they wouldn't turn this information over and sell their users down the river.
Yeah, excellent point. All right. Well, I want to talk, unless, Michael, I'll toss it back to you just for any final thoughts on iTunes Match, because I do think there's a lot to unpack here. We could do the whole show on it, but I think we will move on to other things, unless there is any other further last observation you'd like to make.
No, I think it's too new to observe a lot of things right now.
Okay. So let's talk instead about Twitter and tweets and social media in general, but a specific case where there was an account called OMG Facts on Twitter and a dispute over who wound up owning that account. They have about 2 million followers, and the folks that set it up are in litigation with one another. One who was marketing it and getting the word out and getting all those followers has claimed ownership of the account. There's now some revenue being made. I'm not sure if it's a book or something, as tends to happen with successful Twitter content-oriented accounts. Evan, you tossed this link into our discussion pool. You want to flesh it out for us?
Well, yes. I mean, it is pretty straightforward. You pretty much captured everything about it there. These two collaborators started this account, and now there's a dispute over the ownership of it. And so the point at which we could drill down a little bit on this is examining that issue of ownership and what it means to own this account, and what really is comprised of the stuff that is being owned that's in the account. So it's interesting. It's good fodder for discussion because it brings in a number of different areas of the law here. One of them, we could skim off of the top here, is the ownership of the copyright in the tweets or in the collection of tweets. That's a perennial topic that we love bringing up on the show. Are tweets copyrightable? Is a Twitter stream copyrightable? So one, there's the question of the ownership of the copyright in that. And the other, or at least another issue to talk about here, is the ownership of the business that could be established, perhaps even de facto, around this account. Whether or not the parties intended to do so, it sounded like they may have formed a partnership. So there are assets of that partnership, including the copyright and the goodwill and the other intellectual property associated with the account, but then also the other assets like the revenue stream from that. And so anytime we're talking about issues of partnership, and I'm probably the least qualified one on the call to talk about this, if we've got Edson, with the employment issues and how the partnership issues can relate to that, it seems like this gives a very nice modern day example of how these kinds of issues can play out. And for those of us who have the luxury of kind of armchairing it and looking back or looking out, or looking into this as outside observers, it can be object lessons for those of us who are to either advise people who are starting online enterprises, even if they're very simple like this, or if we're doing our own thing, just to be aware of the various legal issues that can arise, whether or not you intend them to arise or not, when you're going to collaborate with someone, taking on an online project like this. So the reason I like it is because it's nice and simple. There were some unintended things that arose from all of this, and it's a nice little package that we can kind of tie up and see some issues arising from it.
Right, and the other thing I'll throw into the discussion, we talked about it when it happened last year, is CNN has been sort of a revolving door for some of its reporters in light of their Twitter activity. One of them, the fellow we talked about, was Rick Sanchez, who had more than 140,000 followers, but tweeted something in his particular case about Jewish control over the media that lost him his job at CNN. And then there was another very well-known CNN reporter. What was her name? Oh,
Nasser, wasn't it?
Yes, somebody Nasser. Anyway, so Octavia Nasser. So she also found herself separated from CNN after something that she had said on Twitter. She had expressed support for some political faction that CNN thought was inappropriate for her to do so. So the interesting thing that I want to get into with Edson, the headline over on Read Write Web from Marshall Kirkpatrick back when Rick Sanchez separated from CNN was what happens to Rick Sanchez on Twitter, what happens to his Twitter account. And it's a similar issue as these two OMG facts people are considering. Somebody built up the goodwill and somebody else claims ownership. Here we have a classic employment situation where these reporters were arguably using their Twitter accounts for their jobs. And so we have something called the work for hire doctrine, where intellectual property that you develop on the job is de facto and default the property of your employer unless you carve out some other arrangement with them. So, Edson, what do you think about these Twitter situations?
I think that with the Twitter situations, and going back to the case Evan raises, starting with the startups, a lot of the guys who go off and collaborate early on are friends, and they handle their business arrangements loosey-goosey, and so they don't have a good contract that delineates whose intellectual property is whose. And even when a lawyer might tell them early on, hey, you really should sit down and hash out whose intellectual property is going to be whose, they might not want to spend the money on it. And they might think that, gosh, I really don't want to bargain with my friend here that I'm trying to get a business started with. We're trying to all work together and row in the same direction. So they neglect sitting down and really trying to separate whose intellectual property is whose and what intellectual property belongs to the company. Although what a good lawyer should do is sit down and tell these collaborators, look, I mean, we know you think this is going to work, and we hope it does work, but planning for the worst, let's just sit down and try to nail down whose property is going to be whose. In the case of the CNN cases, and with the CNN cases you just discussed with Rick Sanchez, I would suspect that CNN strongly believes that that's its intellectual property, and his Twitter feed, he developed that brand. I mean, I know that Rick Sanchez put a lot of work, his own work into it, but that CNN invested a lot of money getting that going. And I think at the end of the day, Rick Sanchez kind of abandoned that Twitter account. He doesn't use the CNN reference anymore in that. What I doubt happened though is where they just sat down and hashed it out right at the outset in the contract to determine whose property would be whose. So I think that this even when there can be a debate like at the CNN level, which is a big company, of whose intellectual property of whose, it shows how often employees and companies neglect really sitting down and hammering these things out.
Right, and it seems to me we're entering into a world where this is becoming not just over Twitter accounts, but over employees' online presences as a whole, and the fact that many people are coming to jobs with substantial pre-existing ones, or perhaps they develop one in connection with their job and then move on. This is something that's becoming more and more common, and I think rises in a lot of different contexts, which I want to get into in more detail, such as electronic devices. After I go ahead and take a break, we're here with Edson McClellan of Rattan and Tucker here in Orange County, and Michael Barclay up in Silicon Valley with the EFF doing volunteer work, and Evan Brown out in Chicago at Hinshaw and Culbertson discussing all things at the intersection of technology and law. And one of the reasons we're able to do that is through the good graces of excellent sponsors like Netflix. This show is brought to you by Netflix. Netflix delivers movies directly to your home and saves you time, money, and hassle. And for me as a parent, they also save me stress and headache about my children being subjected, I'm sorry, I only have one child, but he frequently has friends over, so it applies to all the children that are constantly running around our house, being subjected to commercials and things that I can't fast forward because whatever it is that they're watching is not DVR'd. And I got to tell you, I really, really stress and lose sleep about all of the commercial programming that is shoveled at children in the middle of their viewing. And I find Netflix Instant to be really helpful in that regard, because when you are selecting their programming from there, of course it's commercial free, whether it's a movie or a television show. Because you've paid their small monthly fee, you are able to serve up that content without the perennial ads for Bratz dolls and Bionicles and whatever else might be thrown in there for them to then clamor at you about to go purchase as soon as they're done watching. So I really, really love that part of Netflix Instant. It is streamed directly to your PC, Mac, or TV via a Netflix-ready device, including Xbox 360, PS3, Nintendo Wii, Roku, Mac Mini. However you're getting your programming up to your big screen, there's a way to get Netflix Instant on there. Plus, of course, you still get the DVDs by mail in about 1 business day. You can watch as many movies as you want, anytime you want. There are never any late fees or due dates. And my pick of the week is something that is appropriate for children, older children, I would say, but I like it a lot too, so it's a fun one to watch with my son. It is the British cast of Merlin, which was airing on the Sci-Fi Channel. I'm not sure if it still is, but seasons 1 and 2 are available on Netflix Instant. It stars Colin Morgan as Merlin, Bradley James as the future King Arthur. There is a sorcerer mentor, Richard Wilson, and of course a dragon that Merlin makes friends with, voiced by John Hurt, and he's just excellent at that. I really like this series. It's a nice twist on the Arthurian legends. We have Guinevere coming in as a castle servant as opposed to the way that she usually enters the story. Morgana is there on the scene, scheming and plotting with her sister Morgause. And it's really quite well done. And they also have Uther Pendragon around. He's not often there in the Arthur story, much past siring Arthur. So it's a nice take on it. It's got beautiful, stunning sets and decent acting for such fare. So I encourage you to check it out on Netflix Instant. Seasons 1 and 2 are there at your beck and call whenever and wherever you'd like to watch them via Netflix Instant without all of the ungainly and unsightful commercials. So if you are not yet a Netflix member, you can instantly watch these when you register for a free trial membership at netflix.com/twit. Be sure to sign up for your free trial there, and we thank Netflix for their support of This Week in Law. All right, Edson, so let's talk about devices, because this is another way I think that this IP issue enters into the workplace. We have this situation where employers issue all kinds of electronic devices to their employees, be they cell phones or computers. We also have sort of the reverse situation more and more these days where, you know, as telephones become kind of more passé, that you might find yourself in a workplace where your own personal cell phone is expected to do duty for you as your work device, or your own personal computer if you are accessing your office remotely through some kind of Citrix or remote desktop functionality. So you have this sort of blurring of lines of, okay, I'm doing work on this device now, but I'm out of the office and I also have to do my shopping list and my calendar and email with my friends and jump on to This Week in Law, perhaps. You know, there are a lot of activities going on that are right in this gray area between work and personal. And so I think that really starts to complicate the whole work for hire IP situation, don't you?
It does. I mean, and I use a lot of, I have to admit, I use our firm's intellectual, information technology resources to, watch TV or to send personal emails. So I do it too. Mm-hmm. And I think it's important for companies to have policies that make clear when employees can use certain resources and when they can't. Because, for example, if you're giving employees phones and you don't tell them that the phones can't be used for personal phone calls, the company can't be surprised later when the employees use the phones for personal phone calls, because that's what most people, including myself, would think they'd be able to do. And so it's very important for companies to tell all their employees, here's what you can and can't do with the equipment we're giving you.
So my problem with that is that the default always seems to be, and I'm sure, Edson, you as a very well-informed and enlightened employment lawyer don't fall prey to this, but the default always seems to be, thou shalt not. You know, this is our device and it is for work-related purposes only. So it doesn't really seem to embrace or take into account reality, if you will, that people, you know, are expected to use these in a variety of locations and contexts, and that thou shalt not simply doesn't work very well. How do you think that situation can be dealt with in a front-end sort of policy?
I mean, it is totally true that even if you have a thou shalt not culture at the office or policy, the employees are still going to want to use the devices for personal reasons. I think if you tell employees that, you know, they're going to have to return their phone calls at the end of their employment, or that you're going to monitor all their email usage, and if you tell employees that everything that they do on these devices, the company can take a look at, the employees are going to be less likely to use the devices for personal reasons. They want to have some privacy, and they don't want Big Brother looking over their shoulder. So even though I do know that even though you tell employees, look, this is for business purposes only, if they get a phone call from their kids on the phone, they're going to answer it.
Right. And as a practical matter, you know, say you're somebody who travels for work, you've got to go through airport security, and you're going to be needing to keep in touch and do things both, you know, in your personal non-work arena and in your work arena. Are you really going to carry 2 laptops, 2 cell phones? I don't think so. Michael, what do you think about this collision of the workplace and IP?
Well, I don't think that the issues are more complicated now that the technology is more complicated, but I don't think they're different than historically the way a lot of things have been. So taking the issue of cell phone or smartphone usage first, I agree with Edson. I think it's up to the company, or smart companies should make it very clear to employees what they can and cannot do. And my own law firm had a policy that pretty much you could do anything you wanted to, personal or non-personal, with the company equipment, but the firm had the right to monitor everything. So that basically told people to abide by what I called the grandmother rule. Don't ever post anything on Facebook or elsewhere that you wouldn't want your grandmother to read. And well, I agree, by the way, that it's unlikely people are going to want to bring 2 laptops through security. There's nothing, a cell phone could be pretty small these days. If you have an employer that you don't want to have the right to monitor what you're doing, you just go out and get a personal phone and leave it at that. I would think that would be an issue. Another thing has to do with the question of ownership of things like Twitter accounts and so forth. Again, there's a pretty well-established area of law in California that defines when an employee owns something and when the employer does. And if it's work-related, and this simplifies a rather complex statute, but if it is work-related, the employer has a good argument that it owns the IP. And again, I think it's probably a good idea for the employer to make that clear to employees. It's also important for employees who think they're doing something that's on their own time or doesn't involve the employer to make sure they understand what the law is and whether they do have ownership rights in these things, particularly if they're using company equipment. Edson, you may want to comment further on that sort of issues.
Right, and Michael's right. I mean, the general rule is in California that if a worker develops some kind of intellectual property on his own time without using company resources in a subject matter that doesn't relate to the company's business, the employee should own that intellectual property. A lot of the complications happen when you get into the kind of the nuances of what relates to the company's business. You know, if you invent something, it's close to the company's business, but it was really only something they were thinking about doing 10 years from now, they haven't done it yet. Is that going to be the companies or the employees? And then a lot of disputes arise about when an employee comes to the company and already has some kind of creation, intellectual property that they'd conceived of before they even joined the company. Then it relates to the company's business because that's where their expertise is. But they don't disclose it. It's not out in the open. And then a couple of years later, they decide they want to sell it or develop it. And the company said, well, that's mine. That's ours. This relates to our business. And the employee says, well, I worked on this years before. And then you'll have a dispute about what was done years before. Was it improved during the time you worked for the company? And so that, while it's nice that there is a labor code provision in California that talks about whose property is whose, there's going to be disputes because the law frequently is gray, and a lot of it's just going to come down to the facts to determine whether the property is the employees or the companies.
Right, and in this era of people being so fluidly between jobs, that it seems like an issue that must come up a lot. Evan, is this any more murky in your neck of the woods? Do you have a similar kind of law?
There is a statute called the Illinois Employee Patent Act that sounds like it establishes a lot of the contours that California law has. An employee, or the way it's phrased, this is actually a statute. It's that any provision in an employment agreement that requires an employee to assign his or her inventions, it's couched in terms of patent law, to the employer is invalid. That provision in the contract is invalid if it was done, there's a kind of a conjunctive test without any of the company's resources on the employee's own time, and it doesn't relate to the things that the company does. If those criteria are met, any assignment to the company is invalid. Any provision in the agreement that would purport to cause that assignment to occur is void. So that is contemplated under Illinois law. And to me, this discussion that we're having, it seems like there are two really separate issues here, both under the heading of the right of the employer to exert power over what the employee does. One is more of a privacy issue, and it could relate to the goodwill of the company, and the other is more of an ownership issue in terms of the work product that the employee does. And I think that conceptually they're quite different. I mean, one is the question of who owns the stuff that's created, and the other is, for example, an employee who's engaging in some kind of misconduct, like Sergeant Kwan in the Kwan case, sending text messages, that could be inappropriate. Or there are plenty of other examples as well. So. I guess the way that I could see this whole, general notion being resolved is to recognize the equities involved in favor of the employer. They are the ones who have outlaid the capital to invest in the devices. I'm talking about work-issued equipment here and the resources to do the job. It only seems fair if they have invested in the capital to provide these things that they should have as a default setting the rights to clearly supervise what is going on and what kind of information is being transmitted out, or what kind of information is being stored on these devices, what have you. The solution, as we see in so many situations that we talk about in other unrelated areas of society and the way that law is affected, or the way that law affects those areas of society, is some kind of development of a sensibility on the part of the employee or the user, in this sense, of the idea of privacy. And it all boils down to this cliche statement that is so tired. Be careful what you post online. Would you want this to be on the cover of the New York Times? Or like you said, Michael, would you want your grandma to see this? I mean, that norm really has to kind of become part of our sensibilities here, and get the end user, the employee, to recognize that this is not ground that you want to be treading on anyway in the first place, whether or not you agree with the premise that the employer should have the right to supervise these things in a very granular way.
Right. So at big companies, of course, you're more likely to get into the situation of, the employer provides the device and has a policy in place about how the device can be used. But at a startup or small organization, you might find people just getting together and loosely collaborating using whatever devices they already have at their disposal. And also, and I must say, for anyone who listened to This Week in Google this week, my thoughts here are being shaded by the fact that Leo is pondering, do we need phones at the new TWiL studio? Because how important is a phone, a regular landline phone to a modern business? And people already have cell phones. So I think this can come up in a lot of contexts, and even in the large company context where, of course, people have their own stuff that they maybe prefer to using their work computers. People sort of cast aspersions on the equipment that their IT department issues, and maybe it's out of date, maybe it doesn't have all the functionality they want, and they go out and they get their own stuff, and they do some of their work on that. So, Edson, do you want to try and address that personally owned device used for work purposes, and do you think that shades the analysis?
Well, I think that when companies offer laptops or phones to their employees and have a policy that at the end of employment they get the phones and the laptops back, the company isn't necessarily offering those phones and laptops just to improve productivity or just to make employees happy. Is to make sure that all the information that's on those phones and computers gets returned to the company. So if an employee maintains a contact list on a cell phone, the company wants that contact list back. And they know that if they give the employee a computer or phone, and that the employee's supposed to use that phone and computer for work, the information that the company keeps confidential is going to wind up on that phone and computer and will come back to the company at the end. If the employee is using his or her own phone or his or her own computer that's personal, at the end of employment, they're going to want to keep that computer and that phone, even though it has company information on it. And then you're going to have a squabble between the employee and the employer, how to get that company information that's on their personal phone and personal computer off of it. Because the employee is not going to want the company messing around with their personal computer or personal phone. And that's why a lot of companies just say, we don't want to deal with that situation. Let's just give them a computer, give them a phone, and at the end of employment, just take it all back. It's not going to solve everything, but it does help the employers control retaining their confidential information when the employment relationship ends.
So the logical next topic, since we've been talking about the collision of IP and the workplace, is the collision of privacy and the workplace. We've covered a couple of instances of police departments demanding applicants' Facebook passwords so that they could have free access to those people's accounts, even if they were not friends or otherwise authorized to look at that material on Facebook, and do a thorough background check on the applicant. That's one kind of situation where this can come up. Other listeners of this show have emailed me offline and let me know that they've been subjected to requests for friending from potential employers for basically the same purpose, to be able to let them go in and freely nose around their Facebook account. So I want to get into this notion of, how private one's online information is, both in the application and hiring process, and then once one is an employee. We've had a lot of stories too about the extent to which one's webmail can be accessed by an employer. Edson, you want to give us some thoughts on that front?
I mean, this is a developing area of law, so I can give you some thoughts, but not a lot of law, because not a lot of law has been developed yet. But what I do know is that at the beginning of the employment relationship, when a person's applying for a job, they have fewer privacy rights than when they're an employee. So an employer has more leeway to say to the applicant, hey, we want this information about you. We want a drug test, or we want to have you pass some medical test, or we want to look at your Facebook account, potentially. And the employer has less leeway to do that once the person accepts the job and is actually an employee. At that point, employees have greater privacy rights. So, the example you brought up is, I believe, a situation where a person was applying for a government job, and maybe they justified it by some kind of security clearance that the company or the government agency wanted to look at the applicant's Facebook account. And I know that this might be being litigated right now. My suspicion is that that's going to be upheld is okay, because the applicant does not have to apply for that job. They can go apply somewhere else if they don't want to hand over their Facebook password.
Right. The National Labor Relations Board, NLRB, has been getting more and more involved in these kinds of situations where people are using Facebook as a platform to discuss working conditions, et cetera. So it seems like they're paying attention to employers' access and perusal of people's online activities. Do you see this possibly being an arena where they would step into the application process as well?
Yeah, possibly, but the NLRB is more interested in employees and about whether employees have the right to ensure that employees have the right to talk about their working conditions and how to improve working conditions and engage in concerted activity. So what the NLRB wants to ensure most is that if employees are online, or either by the water cooler or online or on a social media site, and they're talking about how to improve work, it's too hot in here, we work too long, we should have better resources. The NLRB wants to ensure that employees have the right to talk about their working conditions, whether it's on a social media website or on the basketball court. So that's an area where you can expect them to be, to vigorously defend employee rights.
Right. Michael, getting back to your don't post anything that your grandmother you wouldn't want your grandmother to see suggestion. Did you follow the Ashley Payne story? I think it's not more than a couple of months old here. She was a teacher who was fired not because she had public photographs of herself drinking on Facebook, but because there were photographs of her doing that there from various, I think, European travels. And if the studio, we have some links to some of those photos if you want to put them up while we're discussing this. But someone who was her quote-unquote friend on Facebook anonymously outed those photos to the school district, and she was fired. Do you have any thoughts about privacy and social media and people's employment? And presumably she was applying the grandmother filter to her account, but it wound up biting her anyway.
So remind me, were these photos that she posted, or were they photos that a friend posted that were?
That's another nice wrinkle too, isn't it? Just this week, the EU was investigating Facebook about its facial recognition technology that will match up somebody's face with their identity on Facebook for people who are friends there. And of course, the tagging functionality, if you're out partying with one group of friends and you're friends with work people as well, and your partying friends tag you in a photo of you drinking, then your work people are going to see it too, unless you've actually turned that off. In Ashley's situation, she posted the pictures, and they were on her account, with her active permission, I believe. I don't think, I guess it's possible she could have been tagged in them, but they were just right. There in her account.
It was her account.
Yeah. So do you think that we're headed towards some kind of situation, Michael, where there will be more restrictions on employers accessing this kind of information, or are we just at the point there's Ashley having a glass beer or wine or something, you know, as you would. I think there's one of these
Actually,
photos.
both.
Yes, both.
She's
One
double
of these
fisting it
photos,
already. It's only 2:20 in the afternoon.
She was clearly at Oktoberfest. You know, you got that whole very recognizable atmosphere in Munich behind her, and a big stein of beer from her summer travels after her year of school. And it killed me that someone could be fired just for, you know, having a smiling picture with a beverage in her hand. But apparently it violated, you know, the district's policy, and out she went. So, Michael, any thoughts on this?
So a couple of points. First of all, as to third-party photos, or even your own photos, if you don't like the Facebook video recognition feature, go to the Electronic Frontiers webpage, EFF.org, and they recently posted a video on how to turn that off if you from Facebook if you want to do that. Mm-hmm. My second point is I've observed with new technologies there tends to be a lag between the time they're introduced and people start using them, and later on when people realize the implications of them. So, for example, when email became popular in the mid to late 1990s, a lot of people assumed email was just like having a phone conversation. You hang up and it's gone. And they only discovered later, no, email lasts forever. So people were saying all sorts of things in emails that have since then led to all sorts of civil and criminal convictions where they really shouldn't have said things in email. I think the worst one I ever saw was someone sent an email that said to a bunch of employees with some rather dubious recommendations in it, and said, please make sure you destroy all copies of this email when you've finished reading it. And of course, that email was preserved. So people by now know to be careful about what they put in emails, because if they say anything that could later have civil or criminal ramifications, they know that they'll be around forever. Facebook is still relatively much newer, and people are not used to the fact that, when you put it out there and when you have a reasonable number of friends, and with Facebook changing its own security settings fairly often without telling its users, at least it seems that way, you don't know who's going to be able to see what. So I think in Ashley's case, she probably didn't fully appreciate the fact that these photos would be visible by at least her friends. And if she worked for an employer who said you can't drink when you're not on the job, which sounds like a pretty restrictive employment environment to me, but if that's the case, people who have such restrictions at work or otherwise need to know that they have to be very careful. It isn't just their grandmother looking anymore, it's their employer looking, and they have to be very careful with this. So, again, I don't think that the social awareness of these technologies has caught up to the actual technologies just yet.
Yeah, it was a while ago that I read the stories about Ashley Payne, but my recollection is it wasn't so much you can't drink when you're on the job, but it's sort of like the very fuzzy standards that are applied to judges in our country of having to behave with decorum and not, put yourself in situations where you could be questioned about your good judgment, very fuzzy and amorphous in that sense.
I think most judges have been. Sorry,
go ahead.
I think most judges either are not on Facebook or even have been advised by their respective judicial councils not to go onto Facebook just because of the potential risks.
Yeah, and that's a tragedy in some ways. What were you going to say, Evan?
This was complicated. This Ashley Payne situation was complicated also because it was a parent who complained to the school district, albeit anonymously, and I don't know if she ever found out who the parent was that complained. And also, for what it's worth, I think community standards play a role in this. This was in the southern U.S., and clearly, I'm not going to step into the minefield of trying to stereotype by whole regions of the U.S., but suffice it to say that community standards can play a role in this as to what is acceptable for a teacher or anybody for that matter. And so I think that you have a number of those dynamics going into play with all of this. And just to make one more observation about the Ashley Payne situation, I think all this went down sometime last year or sometime in 2009, and I was at a conference in December where Jeffrey Rosen spoke, and he is from out east. He's the professor out there in New York, I think, right, or Georgetown or somewhere out east. And he wrote that famous piece that we've talked about a number of times, "The web means the end of forgetting." And he used this Ashley Payne situation as the flagship example of the intersection between free speech and privacy. And I'm calling it free speech rather than First Amendment, because it's, if it was a private school or a private employer, it's not a First Amendment issue, but I think this was a public school. And so there is this idea of her speech being restricted by the government like this. And so that's one force driving in one direction, but then in another direction is her right to privacy, either to be completely left alone from all of this, or to tailor her online activities in a way that she's maximizing at least what she perceived to be privacy. I think we've already mentioned that she tried to set her Facebook, or at least this is at least her version of the story. She tried to set her Facebook settings so that only her friends could see all of this stuff. But as Jeffrey Rosen observes, this is a wonderful example, a wonderful context of where these two interests really rub up against one another in a way that gives us something to talk about, and it's a very clear example of how those rights can be contradictory to one another or antagonistic to one another.
Yeah, Beatmaster in IRC came up with a pretty good term for this, electronic prohibition, and thinks it's going to get worse before it gets better. Someone was going to chime in?
Denise, is just Edson, and I work with companies a lot, and what I sometimes find is that some companies are hypersensitive to whatever appears on Facebook that they wouldn't be as sensitive about if they just saw a photograph. For example, in this case with the teacher, double fisting in Munich or something, if they'd just seen a photo of that, like at a tea party or something, to show them a photo, they wouldn't have been as upset. But there's sometimes companies seem to get more upset when a photo or a comment is made on Facebook, and that also comes up with bad mouthing. They might see an email or some water cooler talk where there's some bad mouthing of the boss, and they just say, "Hey, cut that out." But you put it on Facebook, and they get real upset, and companies get real upset. And it's not every company, but there are some companies that are particularly hypersensitive to whatever's out there on Facebook or other social media sites.
Right, and I actually want to get into whether there's a lot of hype about the need for paying attention to these issues in light of social media. And Venkat Balasubramani had a good post on that this week, and I want to question whether we're engaging in cyberspace exceptionalism here, and I want to get into some interesting new e-prohibition kind of laws out of the state of Tennessee. But before we get to that, I'm going to take our second sponsorship break. We're still here with Edson McClellan of Rutan and Tucker in Orange County, and also Michael Barkley up in Silicon Valley with the EFF on a volunteer basis, and also with Evan Brown in Chicago at Hinshaw and Culbertson. And we're here partially under the good graces of Squarespace. Squarespace, of course, is the fast and easy way to create a high-quality website or blog. I use Squarespace. I love it. I recently had someone offer to give me a guest post for Bag and Baggage, and it was so easy to just take the wonderful work that she had put together and format it and throw it up on my site. I think it took about 10 minutes using the wonderfully easy-to-use UI that Squarespace has for managing your website or blog. It's optimized for both beginners and CSS experts, hundreds of design templates to choose from, and you can customize any of them to fit your needs. It has a beautiful iPhone and iPad app for doing your blog on the go. There are online resources and a special support team that give you personal help 24 hours a day, 7 days a week, and they're great. They get right back to you. There's a human being on the other end of this discussion, and they will work with you until you get your problem ironed out, whatever it may be. Their all-inclusive service includes several modules to build your website. There's a blog module, a form builder, Flickr photo display, Twitter widget. They're really good about integrating all these social media tools that can be so problematic for folks out in the workplace. There are Google Maps and more, and there are statistics. All the information they give you, the metadata they give you about your account is really useful and nicely displayed, nice little charts and pie graphs. You know how many times your site is viewed. There's built-in SEO of the nice and Google-friendly variety, not anything that's going to get Matt cuts on your case. There's permission access handling, cloud architecture for speed and site stability. You can use Squarespace for all your website needs. Build it, host it, and update it anytime. You need a 14-day free trial to do this, so go to squarespace.com/TWiL. There you can see the service for yourself, sign up for a free account. You don't need a credit card, just try it out and start building your site. If 14 days isn't enough for you, you can get in touch with Squarespace, and they're really cool about extending that if you still haven't decided to cut bait or fish, as it were, and get your account. I think you will, though, after you try it out. They also have annual plans for a savings of up to 20% off. So go check out squarespace.com/TWiL, and we thank Squarespace for their support. All right, so Venkat, a frequent TWiL guest himself, wrote a piece this week about the fears over social media being overhyped. I think we've just had a slew of examples on why something that someone threw out on our, actually I think they, what do we call it, mentioned me on Twitter, this notion of the law of the horse, that the cyberspace law is sometimes, the modern day law of the horse. And esteemed legal scholar once said, we don't need a whole body of law around horses. It's the same law as governs everything else. And if we're carving out law for when a horse steps on you or how you sell your horse, we're just complicating things and muddying them up. Professor Lessig has his own piece on that, saying, it really is a different species of law, or a different way of thinking about things, a reality that makes us pay attention to things that maybe we should have paid attention to before, but we didn't have to because it wasn't so urgent. Let's start with Edson. Do you think that we need to, first of all, do you think that the impact of social media on the workplace is overhyped?
I think that it's overhyped, the amount of disputes that actually result, the amount of disputes that escalate to actual lawsuits. It doesn't happen that frequently. I take a look at all the new case filings every night in Orange County and LA Superior Court just so I can keep a loose handle on what kind of cases are being filed, and very, very few have to do with employment disputes relating to social media. And I think part of that's because plaintiffs' attorneys aren't sure yet themselves how to craft complaints around this new area of social media, because it's developing and they have easier cases they can deal with right now, and they'll probably wait for that to develop. So you're not seeing a lot of lawsuits, but it is pretty common for companies to have questions about what they can and can't do as far as monitoring employees on social networking websites. And what often happens is one employee will come to HR and say, hey, this other employee badmouthed me on Facebook and said I did all these terrible things. Go do something about it. And so that is a new area of law, and I think it's going to become more, the questions that are going to become more prevalent. I tend to agree, though, that there's a sense that it's so uncharted, we don't know what's going to happen, which really isn't true in terms of how the law developed, that most of the time you can take a social media employment-related dispute and apply it outside of it to some other setting, and the normal legal framework would apply to the other setting will apply to social media. So if someone makes a comment on a Facebook page like that has inappropriate sexual content, And you think, well, what would I do if I found out that that person made the same comment by the water cooler or something like that? You can usually get to the right answer. You just have to apply that same framework and think about it outside the context of social media.
Right. Michael, what do you think? Are we talking about different legal considerations when we have thrown into the mix web mail accounts that, never existed in the early days of email, and, who has access to that kind of material and what the expectations of privacy are?
To some extent, I don't think the issue is clear-cut one way or the other. A lot of the law that exists applies just fine to modern internet-based technologies. Some areas have required their own statutes, such as Section 230 of the Communications Decency Act, which gives internet providers immunity for certain postings made by other people. So in social media, in terms of privacy issues, again, you're dealing with something here that's voluntary. No one forces you to be on Facebook, certainly. No one really forces you to send webmails. And I'm not sure that we need new laws just yet to govern these things beyond what we already have, given that many of them are just so voluntary. If this gets to be something that's so ubiquitous that it does cause problems, then we can revisit whether a new law needs to be made, such as, for example, Section 230 was in that other context.
Right. Evan, any thoughts on this?
I think we need to be careful to examine our motives behind why we're trying to compartmentalize or categorize a particular area of the law. We talk a lot about avoiding cyberspace exceptionalism, and what I understand that term to mean is the application of the law in a special way merely because the factual underpinnings of the situation, whether that be a dispute or some kind of business arrangement or something like that, is based on technology, high technology, usually involving the web or the internet or something like that. That is to be avoided, I think, because the law, as legal counsel and the judiciary does this and the legislative process does this and this thing that we call jurisprudence, what that brings to the situation is ideally timeless universal principles that are unchanging through time, whether you're dealing with something hundreds of years ago or whether you're dealing with something now or whether we're dealing with something in the future. And yes, the course of things does change with the way that overall sensibilities change. I'm not going to deny that things that used to be legal just 50 years ago would be abhorrent to our sensibilities now. But in general, the law needs to be as immutable as possible, as unchanging as possible. So it's dangerous for us to apply the law in a certain way based merely on the fact that there is technological underpinnings or substrate to the particular situation. That is not to say that it isn't helpful for us to think of cyber law, if you will, or the law of the internet as a particular area of the law for the same reasons that I was talking about earlier, and that's because these types of things arise because of particular factual scenarios. Whether a teacher should be fired because of something she posted on Facebook is a legal issue that arises because of a particular factual thing. So it's helpful for us to think of it in those terms. And if we remember, the whole concept of what a court does with stare decisis and, deciding cases based on what has happened in other situations is nothing more than just a series of one after the other activities of analogy making. So if we're going to recognize that we are in a particular factual circumstance, it's much more helpful conceptually for us to do that analogy making if we can think of, this case involving Facebook is a little bit like somebody who posted something on a forum board back in 1997 or something like that. There are, the idea of Section 230's immunity, providing that the intermediary can't be treated as the publisher or speaker. That's helpful, whether it be from an old technology or whether it be something like a one-off, like whether somebody who forwards an email should be entitled to immunity, or whether something extremely new and avant-garde like well, I mean, I'm just thinking of any, modern social media platform where Section 230 hasn't been tried that. I don't think it's ever been litigated whether Foursquare, for example, should be entitled to Section 230 immunity. Those are all helpful in as much as we can make useful analogies, but we don't want to broaden that too far and take our perspective out so far to think that the treatment should be special just because it's a technological substrate.
Okay, well, we discussed the one way that laws are made through stare decisis, which is the Latin term for courts honoring precedents of other courts and interpreting the law. The other way, of course, is through legislatures making law that either is about technology or is broad enough to encompass technology. And we have a couple of good examples this week of some kind of silly and or scary proposed pieces of legislation that are pending. The one of them out of the state of Tennessee would make it a crime to transmit or display an image online that is likely to frighten, intimidate, or cause emotional distress to someone who sees it. Violations can get you almost a year in jail or up to $2,500 in fines. This is from Timothy B. Lee over at Ars Technica. This strikes me as a wildly frightening and or silly bit of potential lawmaking, and puts me in mind of some of those old Usenet groups that would have done a lot of jail time over this kind of activity. But there's plenty of modern images out there that could be interpreted as offensive in some way or another. Professor Volek posted over at his blog that he thinks this is pretty clearly unconstitutional. What do you think, Michael?
I think it's pretty clearly unconstitutional.
Yeah.
It's not only it not only clearly has First Amendment problems, but how do you even know if you're violating it or not? It's really vague. I post a picture, and what even considering different community standards of different places, how am I supposed to know what causes emotional distress to someone in a certain context? I was seeing something this morning that was on Dave Barry's blog. It was some eHarmony user who loved cats, and there was this YouTube video of someone who just started crying all the time because she was thinking about cats. And this is while posting an eHarmony video. Well, almost any picture of cats will cause this woman to start crying. So is that illegal in Tennessee? That's
she better scary. She better stay off the net entirely.
Yeah, I think that's what Dave Verrilli was trying to imply.
Yeah.
So things like that are certainly scary. We could talk about the Protect IP Act if you want to also, but let me know.
Yes, we'll get to that as well in our little segment here on potentially silly legislation. Evan, what do you think about the offensive images?
To be honest, I was trying to find some way to defend it. I mean, the governor did sign it. It made. I suppose that Tennessee has a bicameral legislature. It made it through two houses of its, the state house there. So surely some unintelligent people thought this was constitutional. So, the one way it does seem, and I'm just trying to play the devil's advocate here, the only way that it seems like it could be constitutional is if we look to this requirement that it be posted with a malicious intent, making it more of a statute that deals with preventing harassment and some kind of targeted activity against someone rather than just a pure speech thing. I mean, clearly there are plenty of laws, both in the common law and in the statutory law, that prohibit you from saying certain things. I cannot, earnestly or even, in a certain way, make a threat against the life of the President of the United States, for example. That doesn't violate my free speech, that prohibition on me. So, if I'm going to, with this malicious intent, and if it's proven that I should have known that it would cause someone this emotional distress. Tell me how that's qualitatively different from any other kind of harassment to someone where, I'm saying, I am going to come and get you and cause you severe bodily harm at 2:30 this afternoon. That's harassment. I can't do that. I can't say that. Why is it any different just posting a picture if all those other indicia of maliciousness have to be shown?
Right. It seems like what the Tennessee legislature really wants to do is regulate the internet, have some sort of decency standard on the internet, and since they're not able to keep goats, if I'm saying that right, off the internet, they're trying to impose some sort of penalty on the person themselves that would do that. I don't think it's going to fly or pass constitutional muster myself. Another interesting little tidbit on the legislative front, this comes from Mike Masnick over at TechDirt, and it's particularly interesting to me because a couple of years back, Jonathan Bailey at Plagiarism Today was doing an article on liability around YouTube. And specifically, could you be liable for embedding an infringing YouTube video? So you're not the person who posted it. You're simply using the embedding functionality and you repost it, embed it on your own site. Could you be liable? And apparently there are some senators in Washington seeking to impose liability for just that sort of thing. Senators Amy Klobuchar, John Conran, and Christopher Coons proposed a new bill designed to make streaming infringing material a felony, of all things. So it's a pretty interesting little twist here. Michael, any thoughts on this?
Well, that bill is particularly scary. There are a lot of things on YouTube that arguably infringe someone's copyright. And many of them are subject to a fair use defense, but still that's usually agreed to be a defense. So to say that streaming, which is what YouTube does, could result in a felony conviction would be it would just change a lot of what people are used to doing now. And needless to say, I sure hope that bill doesn't go anywhere. The concern was, and the arguments in favor of the bill were that criminal copyright behavior already covers things like reproduction and distribution of copies. Streaming doesn't distribute copies in the normal sense, so they said, well, let's just have this criminal regulations apply to that as well. And again, the problem is that streaming is temporary. You have to. It doesn't create permanent copies. It's its own different category. In the lawsuit that Viacom brought against YouTube, one of the points YouTube made was if there is an infringing video, people don't get a permanent copy of it. They only can see it just by logging in, and they don't get to keep anything. So there's a lot of differences with streaming and anything else, and I would hope that law doesn't go anywhere.
Right, and I think the twist on this is, maybe the senators would come back and say, well, we're not so much concerned with the copying aspect as we are with the performance aspect, because if you're putting it on your site, that's just another performance for purposes of the Copyright Act, and that's actionable too without proper licensing or authority. Evan, any thoughts?
Just to join in the chorus that this is, this is too heavy-handed. The criminal penalties for any infringement of copyright, regardless of the manner of infringement, whether it be copying or distribution or public performance or display or whatever, those should be reserved only for the most egregious of situations. And to the extent that this is going to subject somebody to criminal liability merely for embedding a YouTube video on their website or their Facebook page or whatever, to the extent it actually does that, I haven't parsed it that clearly to agree with or disagree with the commentators who say that's clearly overreaching, too heavy-handed, and should not pass.
Right. So, Michael, just to round out our discussion of pending and or silly legislation, COICA went away. It is back as Protect IP. I'm not sure how back it is. I sort of lost track of it when it was blocked by Senator Wyden from coming to a vote on the Senate floor. That could be overridden by a cloture, a 60-vote majority. Do you know if that happened?
To my knowledge, Senator Wyden's block is still in place. This week, and you can get links to this on TechDirt, both the LA Times and the New York Times came out with editorials against certain aspects of the Protect IP Act that are most troublesome. The LA Times editorial is particularly interesting because the LA Times, of course, is in the hometown of many of the media companies who would tend to favor the bill. So the Times, that Times is obviously listening to its subscriber base or its home industry base, but it still came out against parts of the bill. And I think both editorials kind of agreed that blocking pirate websites from using credit card services is probably a good idea. The problem with this bill, it goes further, and it does bad things to the domain name system that's been set up on the internet, and does them in a particularly bad way. The LA Times editorial had a link to a technical paper published by some internet experts, and they made several points. One is by blocking, the bill tries to block certain domain names, saying, well, it's a pirate site, let's block it. Well, arguably someone could try to block YouTube that way and saying there's pirated things there. But putting that to one aside, the technical paper makes the points. First of all, it only blocks the name. It doesn't block an underlying IP address. So if people won't know or can learn the underlying IP address, they can just type the string of numbers into their browser and get there anyway. So it's not totally effective. And the second thing was that it interferes in various ways, which I don't think we have to get into in detail here, with the way the DNS system works to make life difficult for the future operation of the system. So there are some real problems with the bill. Hopefully, Senator Wyden, who's done a real good job in paying attention to important technology issues, can either get it returned to the committee or get the House of Representatives to look at these issues and modify the bill in a way that will at least be livable before it goes to a full vote.
So one more point from the Washington side of things is we have a new Solicitor General in the United States. He's Donald Verrilli. He was most well-known probably for his work representing the RIAA in the Grokster case. He's one of the few RIAA representatives to publicly say in open court and on the record that it's lawful to take a CD that you've purchased, upload it to your computer, and put it on your iPod. That point isn't usually so readily conceded. But he did so he has that distinction. Over on our Facebook page, I asked this week if people were happy about having Donald in the Solicitor General role. And for those not familiar with that role, this person represents the government of the United States in the Supreme Court, both when the government is a party to litigation and when the government has an interest but is not a party. So we'll submit amicus briefs that can be persuasive to the justices. And no one over on Facebook seems to like the idea that Donald Verrilli is in that role. Let's see, Evan, and any thoughts about this? Are you uncomfortable with either Mr. Verrilli or the fact that a lot of RIAA representatives have found their way into government positions at this point?
I don't see any reason to think that Donald Verrilli isn't a great lawyer. He's very intelligent, very smart, very successful. So, I don't have any inherent objection to him being Solicitor General just because, his clients were big media. I think that, that should not disqualify him from this. What I don't want to see is any kind of corruption or any non-objectivism on the part of anybody in government because of corporate interests that are affecting them at that present moment or have affected them on their rise. So clearly having him, having represented big media, makes him perhaps suspect. I'll say that. Maybe he should be given some kind of extra scrutiny to make sure that he is free from any kind of bias that originates from that source. But I don't see any reason why just because of some clients that you've had that you should be disqualified from such an important job like that. That's way too much of a subjective ideological reason to think that he shouldn't represent the U.S. government interests. One other way of looking at it is, well, isn't it better that he should be, handling cases like what he'll handle for the U.S. government as Solicitor General? That way, he's not, he won't be handling many kind of big content cases, on the part of the U.S. Maybe an amicus brief here and there that touches on this stuff. But if you're so against what he's done for the RIAA and his other clients, the music industry and the movie and Viacom and the record companies, maybe it's nice to have him out of that particular arena if you want to look at it that way.
That is a nice way of looking at it. Michael, any thoughts?
So a couple of thoughts. One is I hope that when the Solicitor General's office is asked to weigh in on cases involving conflicts between the content industries and the Internet and technology companies, that someone else in the Obama administration will look carefully as to the positions being taken. I mean, remember that YouTube, for example, was pretty instrumental in getting President Obama elected, and yet he just appointed to be Solicitor General the man who actually signed the complaint for Viacom, against YouTube, asking basically that YouTube be shut down. To me, that's a little scary. Now, that does mean that if the Second Circuit appeal that's now pending of the Viacom YouTube case goes any further, that Mr. Verrilli would have to recuse himself from that appeal.
Right.
But there's a related or parallel case in California called UMG versus VO, which involved many of the same issues. It was argued before the Ninth Circuit last month, and there'll be a decision on that fairly soon. One would hope fairly soon. And the question is, will Mr. Verrilli recuse himself from that case where he didn't represent a party? I don't know the recusal rules well enough to know if he has to recuse himself. Or will he just figure, okay, I have a preset position on this. If the Ninth Circuit affirms the district court and rules in favor of VO and against Universal Music Group, I'll help UMG in its petition to the Supreme Court, knowing very well that will help Viacom in its case against YouTube. So I think things remain to be seen as to whether Mr. Verrilli's past record representing media companies carries over to this job, and whether the Obama administration will pay attention to this. I will say that outside these particular areas where media companies are conflicting with the technology companies, I don't know any reason why he's not well qualified for the job in any other area and there are many that the Solicitor General has to deal with.
Right. Well, we will just have to see what sort of a job he does, and wish him good luck and a good judgment in his role as Solicitor General. With that, I think we'll get to our resources of the week. I have a couple of them for you this week. One is a follow-up to our Bitcoin discussion last week. If anyone was more perplexed than enlightened by that discussion, as I think maybe we all were, there is a really good primer on Bitcoin inside the encrypted peer-to-peer digital currency. It's over at Ars Technica, authored by Thomas Lowenthal, and sort of gives you all the ins and outs of the complexities of cryptographic currencies. So I encourage you to check that out. Also, in light of our employment and workplace-related discussions this week, I found an oldie but a goodie on Lifehacker that teaches you how to bypass heavy-handed web filters with your own proxy server. And so if there are things that you cannot get to on your firm or workplace network, this is a way to get around that problem. Of course, you need to bear in mind that you may be violating some sort of policy and or procedure in doing so. So be sure and check your employment documentation before engaging in this. But I know it can be very inconvenient for folks who maybe need to come on our show, perhaps from their workplace, and they have to poke a hole in the firewall to be able to use Skype or whatever. This might be able to help with that. A couple of tips of the week. YouTube finally added Creative Commons licensing in their upload process. Yay! So over at the YouTube blog, they have an example of how that works. It's just another step in the upload. If you want to apply a Creative Commons license, you can do so now. I think this is pretty significant, and maybe we'll stop and just spend a second on this before I go to our second tip of the week, because it certainly helps iron out the copyright difficulties and fair use and licensing difficulties around YouTube videos, which heretofore have been pretty murky. Michael, do you think that this will have good uptake?
For people who want to use it, I think it's helpful. People tend to remix and share YouTube videos quite a bit. Again, a lot of that is fair use anyway, but if you could make sure it's licensed, that's even better. So I think there's no harm in this. It doesn't hurt, and I think we'll see how many people use it.
Yeah, I think as long as it gets sort of the publicity that it needs to gain traction. If you look at Flickr, when it added CC licensing to its upload abilities, it let actually tens of millions of flowers bloom. I don't know what the number is, but the Creative Commons licensed material over there is a vast, vast library at this point. So hopefully it'll be visible enough that people will use it and actually understand that they're using it. Evan, any thoughts?
Yeah, I mean, there's no reason to object to it. The one thing that I am still a little bit puzzled on is why the only license available is the attribution license, which means that any content you post onto YouTube and you designate with the Creative Commons license, it's just the one license that says somebody else can reuse that, provided that they provide you with attribution, which in turn means someone else could take your stuff and put it into a commercial project, make money off of it, and wouldn't owe you any royalties. It would be nice if the full spectrum of Creative Commons licenses was available for content uploaded to YouTube. But otherwise, definitely a step in the right direction.
Yeah, thanks for pointing that out. I didn't realize they didn't have access to the full panoply of Creative Commons licenses, and that is a limitation. Okay, and our second tip of the week has to do going back to iTunes and iTunes Match and the updates to iOS that are coming out in connection with that. I had to click yes on or accept on the latest and greatest iTunes TOS recently. It's 41 pages long. If you would like some help interpreting that, understanding that, gaining enjoyment from that, over at CNET, they have engaged the great Academy Award-winning Richard Dreyfuss to assist you. And I think that there are very few audiences that would have as rich an appreciation for Richard Dreyfuss dramatically reading the iTunes EULA as the TWiL audience would have. So if we could just play a bit of that, I think that would be a nice way to round out the show. Mr. Dreyfuss, if you would.
License is effective until terminated. Your rights under this license will terminate automatically without notice from Apple if you fail to comply with any terms of this license. Upon the termination of this license, you shall cease all use of the Apple software and destroy all copies, full or partial, of the Apple software. Thank you.
Thank you so much to the Reporters Roundtable over at CNET for giving us this chuckle. And I think that if Apple put Mr. Dreyfus on payroll, people might actually pay attention to the EULAs. Everyone enjoy that one. Michael?
That's great.
And that the entire risk as to satisfactory quality, performance, accuracy, and effort is with you.
I do enjoy these. So, I mean, it's a wonderful dig at the fact that no one reads these things and that maybe they need a little help. Any thoughts on this or anything else as we sign off today, Michael? Oop, I think Michael's muted one way or the other.
Sorry. Thanks.
Okay.
Yes, sorry about that. Thanks. I have nothing further to say today, and thanks for having me on the show.
It's been a real pleasure. Thank you so much for joining us. We always enjoy having folks with the EFF come on board. And of course, we know lots of your colleagues, your former colleagues from Wilson Sonsini as well. Kathy Kirkman used to be a regular on this show back in the day. I don't know if you know Kathy, but I certainly owe her an invitation to come back on. So thank you for reminding me about that. And thank you for coming on the show.
It's been my pleasure. Thank you.
All right. Hey, Edson, great to have you on board too, representing from behind the orange curtain here with me.
Thanks for having me. I'm going to go get on my Facebook page and make sure no pictures of me double fisting like the teacher in Georgia. But no, thanks for having me on. I enjoyed it.
Hey, it's been great having you. Like I said, we constantly collide with our geeky subject matter and the workplace. And seeing as how you're a hacky sack master, I think you're an honorary geek for the day for sure.
That's right. Yeah. I just noticed that I was still on there.
Yes, time to check LinkedIn as well.
Yeah.
Loved having you on. Thanks for everything.
Bye.
Take care. Hey, Evan, it's been another fun show.
Yes, thank you very much for having me. It's been an awesome time. Edson, great to talk with you. It's been enlightening. Michael, the same. Nice to meet both of you. I really enjoyed our conversation.
Yeah, thanks,
right.
Evan. I enjoyed that.
I want to make sure I've gotten everybody's respective web presences sufficiently plugged. Evan, of course, is Internet Cases on Twitter and internetcases.com. Michael, you can find it IPDuck, and I do encourage you to check out his blog, which has excellent coverage of both the humorous and the weighty aspects of IP. And Edson, anything that you would want to plug? We have your LinkedIn page as the place where folks can get in touch with you.
Sure.
Anything else?
Well, you can go on our firm's website. It's www.rutan.com, rutan.com, and
That's
there's
right.
a picture of me in a tie and a little bit about me.
Perfect. Or as we sometimes are prone to calling it Rootin' Tootin'.
Yeah.
Instead of Rutan and Tucker. It's like calling it Frisco or Chi-Town. I think it's done but not approved of.
Right.
So with that, we'll go ahead and close out this episode of This Week in Law. If you're listening live, then you already know that we record this show live at 11 Pacific time on Fridays, 1800 UTC. So please join us at live.twit.tv if you'd like to play along as we do the show. Otherwise, you can find us on iTunes, on YouTube, in all of your MediaFly supported devices. And we'd love to have you check out the show in whatever format, whenever, wherever you can. Also, between the shows, please visit our Facebook page at facebook.com/thisweekinlaw. We have lots of good discussions there about things we're going to talk about on the show. You can find me on Twitter. I'm at dhowell, or shoot me an email, denise@twit.tv, if there's anything specific you would like to put in our attention frame or you'd like us to consider. So thanks so much for listening, and we'll see you next week. Take care.